Hello everyone, welcome back to RR Corporates. Our company secretaries are liable for misstatements. Now we are going to discuss a landmark ruling in the case of V. Shankar versus SEBI, Securities Exchange Board of India, a SAT's landmark ruling in a major relief to compliance professionals. The Securities Appellate Tribunal ruled that company secretary is not personally liable for financial misstatements in audited accounts unless there is a clear evidence of involvement or intent. So this video covers the full background, legal framework, and implications of the V. Shankar versus SEBI judgment dated May 5th, 2025. This is a very recent judgment. So the introduction, the background, we are covering a game changing as a ruling from the Securities Appellate Tribunal that impacts every company secretary and compliance officer in India. On May 5th, 2025, the SAT delivered its decision in V. Shankar versus SEBI, setting aside 10 lakh penalty and clarifying once and for all what a company secretary's liability is when it comes to the financial misstatements. Stay with us for the full story and legal implications. Let's rewind. The case concerns Mr. V. Shankar, a company secretary of Dakkan Chronicle Holdings Limited, DCHL, from 2009 to 2011. In the year 2011, the company announced a buyback, and the public announcement bore Mr. Shankar's signature. SEBI later found that the buyback was based on the misstated financials. Loans were underreported, giving a false picture of available reserves. So in 2022, SEBI's adjudicating officer imposed a 10 lakh penalty under Section 15HA of SEBI Act for alleged fraudulent practices. Mr. Shankar appealed to SAT and initially won, but SEBI went to the Supreme Court, which remanded the matter back to SAT in 2023 for a fresh look under the correct scope of Regulation 19.3 of the SEBI Buyback of Securities Regulation 2018. Here, the key legal issues. What was at stake essentially? Is a company secretary personally liable for false or misleading financial statements? Does signing a buyback announcement automatically imply liability? What is the role of compliance officer under SEBI Buyback Regulations? So these were the questions. Legal issues. Adjudicating officer thought so, but the SAT in its 2025 ruling, in the ruling said otherwise. What was the tribunal held? The ruling of the tribunal. The tribunal emphasized a CS, a company secretary, compliance officer, is not responsible for auditing or verifying accounts. That is the job of the statutory auditors and the financial team. The company secretary's role is ministerial, authenticating documents, ensuring procedural compliance, not reassessing financial statements approved by the board and certified by the auditors. The buyback public announcement clearly stated that the board of directors accepted responsibility. Shankar merely signed in his official capacity. There was no evidence of Shankar being involved in the preparation, manipulation, or concealment of financial data. SEBI failed to establish any specific legal provision that Shankar had violated. So the legal interpretation, section 215 and regulation 19.3, SAT reviewed section 215 of the Companies Act 1956 requires directors to approve the financials. Regulation 19.3 of SEBI Buyback Regulations mandates the CS to act as a compliance officer but not to audit financials. The tribunal made it clear signing is not equal to the liability unless there is a proven misconduct. Why the penalty was set aside? SAT held that penalties can't be imposed based on the presumptions or misplaced expectations. There must be a specific legal duties breached, which wasn't in this case. No material showed that Shankar knew or was complicit in any fraud. Thus, the appeal was allowed and the 10 lakh penalty was set aside. The implications for CS and the compliance officers. This is the landmark decision because it protects company secretaries from undue liability just for signing documents. It separates the authentication role from the certification role. It reinforces that boards and auditors bear the ultimate responsibility. But the caveat is, if the CS is actively involved in misrepresentation, liability still applies. This judgment also reiterates that compliance roles must be defined realistically, not just legally. So the key takeaways in this case, CS and compliance officer aren't the auditors. They are not the auditors. Don't assign blame based on the signature. SAT's judgment brings clarity and balance to corporate liability. Always document your role. Keep compliance process transparent. Like, subscribe, and share for more updates on corporate law and governance. Please subscribe to RR Corporates, and we have other channel, RR Legal Talks. Thank you.